Yeah. All right. Hello and welcome to lucky episode 13 of the Immigration Podcast. It's an auspicious occasion, and for such an auspicious occasion, I have invited Mr. Ratanio Rucker to be our guest today. And Ratanio, give him a little bit of background about yourself.
All right. Well, first of all, good afternoon, Rob, and thank you very much. I appreciate it. I am a trial attorney of over 38 years. For 20 of those years, I sat on the bench, 5 as an acting judge, and 15 as a magistrate down in Cuyahoga County Juvenile Court. I have had vast experience over a number of areas, including civil, criminal, custody, and even immigration and divorce. So.
Yeah, and that's why I thought it'd be a good idea to have you come and talk to everybody today because so much of what's going on right now involves the courts and fear of access to the courts.
Yes.
So many people are afraid they're going to go to court and next thing they know they're in some foreign land randomly. Um, but it's an important issue because especially in the juvenile courts, in the family law courts, people need to really take advantage of some of the things that are offered in those courts, but also to not be afraid to utilize the services of those courts.
Right. I agree with you 100%. Unfortunately, many people right now, the atmosphere is such that many people are afraid. And I can tell you from experience, one, most municipal courts, if not all, are not really concerned about calling ICE or anyone else if you have a traffic ticket or some other kind of misdemeanor criminal action in the municipal court. So that's the first thing.
Yeah.
But it's always good to have an attorney who understands immigration to go with you so that they can try to help navigate some of those issues. The other thing in the family courts is in domestic relations and also in juvenile, I have not seen anyone be called in terms of ICE or be detained because of ICE, and nor have I heard of any instances where the court has, in either instance, detained people because of a request from ICE. So I think it is a lot easier to access those services. And I think it should be a little bit less fear as opposed to going down to the criminal division of Cuyahoga County Common Pleas Court, where a felony could, in fact, get you detained and also removed because someone may have to call ICE depending on what the felony is.
Yeah, and one of the things that I've seen in a lot of news reports is as ICE has had these kind of rolling enforcement issues. Most recently, they were just down in Columbus. Um,
Mhm.
you see the news reports about people keep pulling their kids out of school because maybe the child doesn't have any kind of legal status or the parents don't have a legal status. And, every time I see that, I'm thinking, you're more likely to get involved in the system through the truancy process than you are if you just let your kids go to school.
I agree. And I have not heard of anybody in Cuyahoga County, their children being pulled out by ICE in Cuyahoga County. Now, it doesn't mean it won't happen, but I agree with you. If ICE is not here, you should let your children go to school because the truancy process targets parents. It does not target children. And parents are responsible for making sure that their children go to school. And if they don't, then there's a problem.
Yeah. So let's ask about kids. And there's a lot of kids in the United States right now that don't have legal status. Um, if those kids run afoul of the criminal system, they're going to be in juvenile court.
Right.
And talk a little bit about how that criminal system works for juveniles and especially when you don't have status.
Okay. It is very similar to the adult court in that you have what's called an arraignment, which is where the court brings you in, asks you if you understand the charges that are being brought against you, reads you your rights, ask you if you understand your rights, and then ask you to enter what's called a plea. You can either enter a not guilty plea, you can enter a no contest plea, or you can enter a guilty plea in juvenile court at the arraignment. Now, if you are not from a United States citizen, if you are not a United States citizen, then the court is required to ask you what your citizenship status is. They are also required to provide you with a court appointed interpreter who speaks your language, which is very important because a lot of times, especially in our Hispanic communities, um, our Hispanic community individuals will nod as if they understand what you're telling them, but they really don't.
Yeah.
And they make it seem like they speak English, but they really don't understand what you're saying. So it is important that we get um, a Spanish interpreter. Once that happens, then the case is set for what's called a pretrial, where you have an attorney or you're appointed an attorney at the arraignment stage, and that attorney, who whether it's the public defender or private attorney, they then ask for discovery or what the state's case is against the child. And then at that particular point in time, if they can resolve it, fine. If they can't, then the case will be set for trial and there will be a trial that will be had. At all stages, you are entitled to an interpreter who speaks your language so that you can understand what's going on. And sometimes, if the matter goes to trial, sometimes you have to have an interpreter sitting at this table with the child, but then you also have to have an interpreter sitting in the back for the parents or the guardians. Okay, whether that be grandparents or whoever. So, and yes, that is court appointed, and that is a cost that the court has to absorb because that is required by, if I'm not mistaken, Ohio Rule of Superintendents 88. So the
Well,
Supreme Court requires that.
yeah, and that's something I don't think a lot of parents understand is even, if your child grew up here, even if they don't have legal status, they may speak perfect English, but you as the parent don't. And you
Right.
as the parent in that situation, when your child is under 18 in the juvenile court, the court can give an interpreter to you so that you know what's going on with your child.
That is true. And in fact, they are required to because the bottom line is it's not just the child in juvenile court. Even if the child is 18, it's not just the child. This juvenile court, you are a child in juvenile court. That's why the court has jurisdiction until you're 21 or in certain cases beyond 21. We won't get into those cases because those are the worst case scenario
Yeah.
cases. But you are considered to be a child for the jurisdiction. So because you are considered to be a child, even if you're 18, you need a parent or a guardian ad litem. So yes, as the guardian or the parent, you are entitled to a Spanish interpreter under that superintendent's rule 88.
Now, if your child is a citizen, but your status is maybe a little bit more questionable, should the parents have any fear of attending those hearings or working with their child in that juvenile system?
I don't think so. Again, I have not heard of any instances in which ICE has come to a juvenile court and has started to detain people. Mostly they've been at the federal court system, from what I understand. Okay. Or going to certain places where they believe certain individuals congregate.
Yeah.
I didn't want to say that the wrong way.
Yeah.
But my understanding, like they'll go to the Home Depot or they'll go to certain areas where they believe that certain types of individuals congregate. So I have not heard of that. But if a parent is concerned about attending the hearings, they can ask the court to appoint a guardian ad litem for their American citizen child. And that guardian ad litem will stand in the stead of that parent so that if the parent has that fear. The other thing is this: even if the parent has that fear and a guardian ad litem is appointed, the parent can still attend the hearings. And if the charge is domestic violence, the court will automatically appoint a guardian ad litem because the parent's interest in that case is much different than the child's interest.
Yeah. Yeah.
But in the instance where it is not a domestic violence case or an assault case or in a case of violence involving the parent, you have to ask for that guardian ad litem if that is your fear.
And if you are a parent of a kid that's whether the kid has any status or not, but if you're the parent of a child in juvenile court, does the juvenile court even ask or care what the parent's nationality is or status?
No, they do not. The only thing that they care about is, do you understand what we are doing here today? And most of the magistrates and judges in juvenile court that I am aware of, because I have served with most of them, at least the older guard that I serve with, they will ask you, what language do you speak? They don't ask you where you're from. They just ask you what is the language that you speak. You tell them, and if you don't understand, they will appoint a court interpreter that speaks your language so that you can understand. Because in juvenile court, the parent and the child are joined at the hip, so to speak.
Yeah. Yeah. Now, in those situations where, like, maybe it's a U.S. citizen child, but things have gotten a little bit unruly, and the parents don't have any legal status, are they able to seek any kind of resources through the juvenile court?
Oh,
Maybe the
most
police
certainly.
haven't gotten involved yet, but you know,
Most certainly. The juvenile court they have what's called a diversion center where they offer various services to the parents and the children and try not to put the child in court proceedings. All right. And you don't go in front of a judge or a magistrate. My understanding is it has been approved by the Cuyahoga County Prosecutor's Office, and that was done some time ago. And they send you to counseling. They give the parents counseling, how to be better parents, that kind of thing.
yeah.
There also is something in juvenile court under the statutes that's called being an unruly child. That's when you actually put the child in court proceedings at that particular point, and there's a whole bunch of stuff that goes on. But the court itself tries to make sure that the child does not have to be, if it's just a matter of being unruly. If it's a matter of being criminal, that's different. They also have diversion programs for that as well for first time offenders. But unruly children, they try to deal with outside of the actual court system.
Well, and it's a situation that I don't think any parent wants to be in. But if you are a parent of a U.S. citizen child and your status is, again, undefined, there are processes for you to be eligible to adjust status, either under U visas or other Violence Against Women Act type visas, if that U.S. citizen child is impacting you,
Yes,
violent or aggressive. There is a way to do that, and I don't know that any parent ever wants to have to go down that path. But if your child needs help, especially if there's mental health issues or drug addiction issues, the help is there. It may also provide a resource for you as a parent to correct your status so that you can continue to be here and help your child as they try to navigate the complexities of teenage years.
true. When I first started as a magistrate, the domestic violence charges were low.
Hmm.
When I left in 2022, they had increased a hundredfold. So if you have a child that has been domestically violent towards you, the bottom line is I would suggest that you talk to an immigration attorney to see if you are eligible for that victims of crime visa. I understand no one wants to get or earn status in that particular way, but it is a way to earn status. Yes.
Yeah, and sometimes the more important side of it is, you got to get help for that child. You can't let some of those things spiral out of control. And so you should, as a parent in that situation, you shouldn't be afraid to get the help your child needs, because there may be some long term benefit for you, but more importantly, to get that child help.
I agree. And we have a number of different agencies, such as Catholic Charities, Murtis Taylor, all around the county that offer services for children and parents and families. And even if you don't go through the juvenile court, you can always go through these other places that offer those services. And I believe some of them are free. And if they're not free and you have health insurance of some type, I believe that some of them do take your health insurance. And that is very important.
Yeah. So let's transition over to the family situation, because I know you do a lot of work in the family courts, and divorce, child custody, child support, all those things. Your legal status in the United States doesn't really matter
No.
to getting access to those kind of court proceedings, right?
No, it doesn't. And there are for divorce cases, even if you are married in another country and you want to be divorced here, or you are married in this country and want to be divorced here, you can go to the County Court of Common Pleas Domestic Relations Division. All right. But you have to make sure that you meet the residency requirements. For the state residency requirements, you have to have lived in the state of Ohio here for at least 6 months. And for the county requirement, you have to live in the county in which you intend to file for 90 days. So that means that, say, for example, you've lived in the state of Ohio for 6 months, but you've only lived in this county for 2 months. You can't file here, nor can you file in the county in which you used to live in. Now, you can also file, or depending on which spouse you are, whichever spouse meets the residency requirements, they can file for divorce. And there's two types of petitions that you can file for. You can file for a petition of dissolution, or you can file for a complaint for divorce. The petition for dissolution is where everybody agrees on everything. They agree on property settlements, they agree on debt distribution, they agree on parenting issues, the whole bit. And everybody goes their own way, but you have to agree. If you don't agree, you've got a problem. That's when it's going to turn into a complaint for divorce. And that complaint for divorce, they look at everything. They look at your property, they look at your retirement accounts, they look at how long the marriage was, they look at whether one party or the other are entitled to spousal support, they look at custody in the domestic relations issue, they look at it all. Now, you can also do a legal separation, but a legal separation does not have any kind of residency requirements. So that's a whole different animal. But once you get divorced and you are from another country and you were married in the other country, then you need to check with your consulate to see what their process is to get your divorce recognized in your home country. Okay, I know in Mexico, you have to get a certification from, I believe it is the Supreme Court of Mexico or something of that, but you need to check with your consulate to see.
Yeah, and so the American court, though, if you have children with your spouse and you're getting divorced, even if one or neither of you have any kind of legal status in the United States, the American court still has the authority to enforce child support payments, spousal support payments, any of those types of things, right?
They do, especially, as long as you have met the residency requirements and you have filed for either divorce or dissolution, then yes, they have jurisdiction to do the initial order. And they also, unless the parties agree upon certain issues like spousal support, that they don't retain jurisdiction, then generally, with respect to child support, they do retain jurisdiction to do post decree motions. Yes. And it doesn't make a difference what your status is.
Yeah. Now, if you're the victim of a violent spouse, or you're in need of divorce and separation quickly, should they fear coming there and seeking the help of the court? Is there a reason? Is the court going to report them for their status?
To the best of my knowledge, I have not heard of a situation where the Cuyahoga County Domestic Relations Court has reported anyone, just like with the Cuyahoga County Juvenile Court, nor have I heard any situation where ICE has showed up there for any reason whatsoever.
And
So,
is there anything under state law that mandates them that they would have to report you if you didn't have status?
to the best of my knowledge, no.
Yeah, yeah,
So
I
I
don't think so.
I have not seen anything. I don't even know under federal law, under the current Immigration and Nationality Act, that any state is required to report you for anything, or any court in the state is required to report you. I think that that is more of a DHS directive,
Yeah,
trying to get into agreements with various law enforcement agencies and various courts to do certain things. My understanding is some courts have declined, and some law enforcement agencies have declined to enter into those. But then we have the famous sheriff from Arizona who decided to enter into that agreement and was doing that. But this is
yeah.
not Arizona.
Yeah, and I think the important thing is when, especially if you're in a situation where you're not physically safe, um, you should not be afraid to avail yourself of those court processes, and you can contact someone like yourself to get some of that advice as to what can I do and what can't I do in
Right.
those courts.
Now, also, the domestic relations court, if you're in a violent situation, the
Mhm.
domestic relations court can, in fact, if you file for divorce, they can, in fact, issue a protective order against your abusive spouse, which will be evidence for the victims,
Yeah.
for that kind of status, for victims of crime or the VAWA. Did I say that correctly? I
Yeah.
hope
The
I said
VAWA,
that correctly.
Violence
Okay.
Against Women Act. Yeah. Yeah.
There you go. So that could be evidence, especially if it's temporarily granted, and then if it's permanently granted for whatever period of time they decide to grant it, which I believe is up to 5 years. The bottom line is that would be proof in your immigration case as to, especially if the individual is an American citizen, that would be proof. And even if you have an American citizen child who's over 21 and they are abusing you, you can seek that protective order, and that could also be evidence for your VAWA situation, as I understand it.
Now, if you are in a relationship where there's some violence or you have some fear, stalking, whatever, does it? Uh, if you're not married, can you still seek those civil protection orders?
You can, but they are handled there. If, for example, if in fact someone um, has brought charges against someone else, they've gone to the prosecutor's office, then the municipal courts will normally issue a protective order as part of that case. But there is a separate process that you can go through the county in which you can get a protective order, a civil protection order through the county. Also, in juvenile court, if you have a child and that child has been abused by someone, you can get a civil protection order in juvenile court. And if you're an adult who's being abused by a child, you can go to juvenile court and get a civil protection order.
And that's helpful because so many people live in fear that if they try to avail themselves of help, they may face deportation or something like that. But the reality is, those courts and those services, they're not looking to report people or to see anyone deported. They have a job there to intervene and provide assistance.
That is true. The domestic relations court main focus is families. And I don't know if people know, but over the past several years, they have done everything they can to put in place services for people in families so that they can maintain them either together or so that when they do separate, things go as smoothly as possible. The juvenile court's main focus is children and families. And I will tell you, if you are an individual who has a child that is abusing you, um, there is a process by which you can get that CPO, but also understand that if it is a situation that demands the court's attention, they may give notice to Children and Family Services who may come in and they may investigate and they may determine that the child no longer can be in the home. And
Mhm.
that is a whole, that's not ICE, but that is a whole different situation because they may take the child out of the house because it's either not safe for the child to be in the house, or when I was a magistrate, I would give notice to Children and Family Services because the child was abusive to the parent and that it was not safe for the parent. And at that particular point in time, Children and Family Services a lot of times would put in services into the home to help the family so that the child would be safe, but the parent would be safe as well.
And that doesn't depend on your legal status. I mean, that's something that those
No.
are services for the family and for the child. Doesn't matter what your legal status is.
No, it does not. The services offered by domestic relations and juvenile court have nothing to do with your status. It has to do with, do you live in our jurisdiction? Do we have jurisdiction? If you live in our jurisdiction, you meet the residency requirements, then you're good. For example, in juvenile court, you can always file a motion for custody as long as you meet the residential requirements. And that's to originate a custody action. Now, if you want to modify a custody action, you can do that too. There is no time frame to modify a custody action, but you have to meet certain things. Now, for an emergency motion, there is no residential requirement. You just have to know, is the child in immediate danger or are they being abused and neglected? Excuse me. And if that's the case, you can file an emergency order at any time, and that can be either parent, that can be a guardian, and that can be a third party. Interestingly enough, the United States Supreme Court has said grandparents do not have custody rights in the United States. But as an interested third party, if they observe abuse or they see the child as an immediate danger or they see the child as being neglected, they can in fact file under those circumstances.
So the one thing that I want to make sure we cover, and I think it's really important. I just seen another young man in my office a couple weeks ago that um, he's now 21, but he came to the United States when he was about 14 and um, didn't know, didn't understand, and that's the under immigration it's called special immigrant juvenile status, but in the juvenile courts it's kind of referred to as a ward of court.
Right.
When in Ohio, some states it's up to 21. In Ohio, it's an 18 state. But if you're under 18 and you've been abandoned or abused or neglected by one or both of your parents, you can qualify for this special immigrant juvenile status. It's a pathway to a green card, it's a pathway to citizenship. But it starts not in immigration court, but in juvenile court.
It does.
And so,
And
yeah, so if you're a kid, if you're maybe even a single parent, what's that process look like? How do you initiate that
all
other than
right.
call me or call you or you know?
Well, the first thing they need to make sure that they met the residency requirements because the ward of court or special immigrant juvenile status is essentially a custody motion that you file in juvenile court. So you have to meet the residency requirements. So if you have not lived in the state for 6 months, you can't do it. If you haven't lived in, but if you've lived in the state 6 months, but you haven't lived in the county where you live for 90 days, you can't do it. So you got to first meet the residency requirements.
Mhm.
Secondly, you should consult an attorney who does custody cases or ward of court cases because the bottom line is you have to file in the juvenile court in order to get custody. Now, these are not emergency custody motions, they are just regular custody motions. But they also request that the court give those special immigrant findings, juvenile immigrant findings. Okay. There are two counties that I am aware of, though, that it may be difficult for you to get that if the child has not been abandoned by both parents. Now, you and I both know that the federal law allows for a finding of those special immigrant status, juvenile status findings, where one parent is remains in the country of origin, or but another parent is here in the United States with the child. We know about that, but Franklin County and Stark County um, may not necessarily agree with that finding. And they may require that both parents not be here in the United States and the child has been abandoned by both parents. But you don't, under the federal law, you don't need abandonment by both parents.
Yeah, and that's something that I think is really key to talk to an attorney or like you said, Catholic Charities has a very good service and because the rules are different because it's a county by county issue. It's a elected probate judge or elected juvenile court judge by elected judge, depending on what county you're in. So it can be
Mhm.
very, very different.
That is true. Now, I can tell you, I am aware that there is a case out of Franklin County, 10th Appellate District, that does not agree with the federal law. But I am also aware of a case that I participated in when you and I both worked together, okay, at an immigration law firm that I participated in which we got those special juvenile immigrant findings out of Franklin County. So it's county by county, but it's also going to be jurist by jurist in those counties.
Yeah, and even individual by individual. I mean,
Yes,
every case is completely different. It really is, and you've got that's why you really need to talk to someone or consult with someone. The important thing is to know that this pathway exists. You know,
right.
if you're under 18, if you know, the, so many kids don't know about it, and I think the more important thing is like school administrators and ministers and churches. They're doing all these things to help kids that are in this situation, but then they don't know about this program that I think really probably has the most could have the most impact
Right.
for those kids.
And there are certain things you have to do. For example, if the one parent is still in the country of origin, you have to serve them by publication if you don't have the address. You have to pay attention to the details in
Yeah,
order to have it properly before the court, in order for to have it stick. And once you follow the details and you do all that, and you get a judge or a magistrate who is willing to follow the law, then you can get those special juvenile court or juvenile immigrant findings. And next thing you know, you're on your way to a ward of court and on your way to status.
yeah, yeah.
So,
Well, and I think, from my perspective, I think one of the most important things for anyone here to consider is if you're in a situation where you're not comfortable, you're not safe, you don't feel safe, there's services out there in the family and the juvenile courts, and your legal status doesn't necessarily matter. Um, Talk to an attorney if you need to, but take advantage of those services.
right. And again, both courts within the last 10 years or so have put in a number of services. The Intervention Center in Juvenile Court, big addition,
Hmm.
trying to help families without putting them into a court system. Various cities, in terms of the criminal aspect of juvenile court, various cities have first time juvenile offender programs or diversion programs, which is important, which is one of the things I did when I used to live in Columbus, Ohio.
Yeah,
Uh, for 5 years, I would come up one Saturday a month from and go from 10 until finish. And the bottom line is, I would hear cases in the city of Cleveland's diversion program for first time juvenile offenders. And I'm telling you, it works wonders because
yeah,
it keeps the kids out of the system. And that is a service that it doesn't make a difference what your status is.
yeah.
They don't care. What they're trying to do is get you help so that you don't come back.
Right. And if you don't get that help, you run the risk of impacting your legal status here or your future ability to get legal status here, and that's a huge thing.
I
Well,
agree.
for those that are watching that are not from our local area, that's not a filter on my windows. That's actually Cleveland
That-
weather. That's what it looks
that's
like
lake.
here in Cleveland. Yeah, yeah,
That's lake effect snow. Yes, that
yeah.
is lake effect snow, people.
Yeah, December till well, May.
Sometimes May.
That's what it'll look like out the windows. So yeah, good to have the corner office these days. So, Retario, excellent to see
Ackie
you.
window reporting.
Yeah, yeah, good to see you, buddy. I hope everything's going well for you. I'm gonna have your information, your contact information, up here on the slide at the end. Anybody has any questions about the juvenile, the family, the criminal courts, you're a good guy to know.
All right. You're more than welcome. And thank you for having me on. And happy holidays and happy new year to you and your family.
Yeah, one more for people our age. It's
Hey, I'm thankful. It's better
exactly.
to be seen than viewed. I'm
Yeah,
just saying.
exactly. All right. We'll see you. Take care.
All right. Take care, man. Talk to you later.